The rules of this jurisdiction require that I read the following statement to all in the courtroom today. Before we begin trial, I have a brief message to share with today's participants. We all have feelings, assumptions, perceptions, fears, and stereotypes about others. Some biases we are aware of and others we may not be fully aware of, which is why they are called implicit biases or unconscious biases. As participants in the Ohio mock trial program, it is important to resist jumping to conclusions and acting upon personal likes or dislikes. Resist letting bias, prejudice, or public opinion influence your behavior inside or outside of the courtroom today. Please treat all individuals with respect, regardless of ability, gender, race, religion, ethnicity, sexual orientation, age, national origin, or socioeconomic status. And with that, we are now then ready to proceed with the opening statements. And just as a matter of procedure, what we will do is do the opening statements first, and then we will pause and have the bailiffs swear all four of the testifying witnesses today collectively, and then we'll move into the defendant's case in chief. So now, with that, when the defense is ready with opening statement, you may do so.
Your Honor, I would first like to introduce our counsel today.
Very well, good.
Good morning, I am Mariana Tai, and along with my co-counsel Taylor Bays, we will be representing the defense.
Morning.
We will be calling as witnesses today, Micah Pessa, played by Markia Williams, and Charlie Nguyen, played by Cassie Stanger.
Okay, good morning.
Thank you, Your Honor. Your Honor, may it please the court. We are here today to get justice for two victims, Micah Pessa, a young lady at the mercy of the law, and Hamaya Robbins, a young person whose soul cannot rest until she receives justice. We ask the Honorable Court to allow Micah Pessa to withdraw her guilty plea under Rule 32.1. Micah was accused of and pled guilty to a crime she did not commit, a murder of her dear friend, Hamaya Robbins. Under the recommendation of her trusted counsel, Micah Pessa accepted a plea deal believing it was her best option. Little did my client know her actions were taken without knowledge of an important change in the evidence against her by the state. That Corey Abrams, the eyewitness that identified her as the person seen fleeing from the crime scene, had recanted their eyewitness testimony. Had Micah known this, she would not have pled guilty, that she did not commit. The landmark United States Supreme Court case, Brady v. Maryland, held that the suppression of evidence by the prosecution favorable to the accused upon request violates due process where evidence is either material to guilt or punishment. She is entitled to withdraw her guilty plea. It is important today to keep in mind that though Micah did not commit this crime, she is not required to prove that in order for the relief request to be granted today. The standard for allowing a defendant to withdraw their guilty plea is manifest injustice, which plainly occurred here, as her 14th Amendment right to due process was violated. The defense, which carries the burden of proof, will prove today that 1, the state failed to disclose material exculpatory evidence within their control, the recanted eyewitness identification, and 2, Corey Abrams' suppressed statements had a reasonable probability of leading to a not guilty verdict. I suspect today that you will hear that Micah Pessa was a troublemaking young lady who was angry with her friend and murdered them out of rage. I suspect you will hear that Micah has a criminal past and was seen as the person fleeing from the crime scene. I expect that the prosecution will try to convince the Honorable Court to dismiss the motion under a technicality of timing and circumstantial evidence. The defense will call Charlie Nguyen, a licensed private investigator, who will testify that all of the evidence is weak and cannot definitively help investigators draw conclusions as to what happened on the night of Hamaya Robinson's murder. The defense will also call Micah Pessa, the defendant. Micah will give background to some of the events that occurred on August 31st, 2019, provide an explanation for some of the physical evidence left at the scene, and provide insight as to why we are all here today. I can state with great certainty that the defense will prove that Micah Pessa is a young lady who has made some mistakes, who has a nonviolent criminal past and is truly a caring, loving friend. There are two victims in this matter. Hamaya Robbins, a young person who has a life ahead of them, a victim of violence, whose family seeks justice. and Micah Opesa, a young person who was the victim of a flawed system, a victim of the court's injustice whose only fault was being afraid. We ask that the court does not again fail Micah by not giving her the justice that she deserves, and doesn't fail Hamea by not giving her the justice that she deserves. Micah does not deserve to sit in a jail cell for a crime she did not commit. And Hamea Robinson's family does not deserve to believe that their justice has been served when it certainly has not. We plead with the honorable court to allow Micah Opesa to withdraw their guilty plea under Rule 32.1 to avoid manifest injustice. Thank you.
Thank you, counsel. And then when the prosecution is ready with its opening statement, you may do so.
Thank you, Your Honor. First, I'd like to identify who's representing who in this case.
Yes, certainly.
Your Honor, I'm Trent McCann. I will be representing the prosecution. My co-counsel is one Preston Grooms. Good morning, Your Honors.
Good morning.
We will be calling two witnesses to the stand. The first, River Foley, played by Rachel Boland.
Good morning, Your Honors.
The second, Kai Robbins, played by Madison Ritchie.
Good morning, Your Honors.
Good morning.
Your Honors, may it please the court and opposing counsel. Good morning. The case presented before you today is simply a matter of justice that was served and how it must be upheld. And as such, today, the state of Buckeye respectfully requests that the defendant's motion to withdraw their guilty plea be denied. The defense's case rests solely upon the reservations of an eyewitness whose original account was immaterial. May I ask that the witness, Madison Ritchie, mute her mic?
No, they see us. They see us. Go.
They will operate under the false allegations that the defendant's due process rights were violated due to the withholding of the recanting of a witness statement. The truth of the matter is solely that the defendant's rights to due process were not at all violated because there was no trial, and Brady and Giglio are meant to secure fair trials, not plea negotiations. Besides that, the defendant's guilty plea waived the right to a fair trial. Therefore, the state of Buckeye had zero, again, I said zero, obligation to turn over any evidence before the trial phase, and Brady and Giglio do not apply in this instance. Now, the defense will claim that since the witness had reservations about their identification of the suspect, that it constituted enough change in the case that the already overwhelming amount of material evidence against the defendant would not have been enough for a guilty verdict, and therefore the defendant would not have taken the plea deal. Today, the prosecution will tell you the truth in regards to how the defendant already had a copious amount of evidence pointing to their guilt without the witness statement even being factored in. Now, the true story behind today's case goes as follows. On the chilly fall night of August 31st, 2019, the victim, Hamea Robbins, was brutally murdered in cold blood by one Micah Opesa. There was a plethora of evidence placing him there that night and plenty of motive. Knowing this and being fully aware of his own guilt, Opesa, with the advice of his own attorney, knowingly and fully voluntarily agreed to a plea deal in which Brady and Giglio does not apply to. A plea deal in which Opesa was fully aware of the plethora of material evidence against him. Again, I add how the prosecution had given all the material evidence over to the defense, and in which they had no obligation to do. They also had no obligation to turn over any immaterial evidence as well. Now, despite what the defense may say, Micah was no angel. She was not this tragic kid with a tragic past and some bad news behind her. The history of legal activity and bad behavior across the board was not in the past and was fully in the present as well. Justice was served and must be upheld. Your Honors, first, we will be bringing River Foley to the stand. She will give her insight in regards to the physical evidence found at the crime scene and how it clearly points to Micah Opesa's guilt. The experienced Detective Foley will also show that one eyewitness's reservations would not have changed the case against the defendant enough to be material under Brady or Giglio, which don't apply to begin with. After the crucial testimony of Detective River Foley, we will bring in the mother of Hamea, Kai Robbins, to the stand. Kai has an extensive history with the defendant and will give crucial insight to the defendant's troubled past. She will also give the full story of what happened the night of the murder. In that regard, she will show how Micah had shown motive for the murder and how she learned of the threats that she had made against Hamea before she killed her. The simple fact of the matter is, justice was served and it must be upheld. The evidence against the defendant, not even including the witness statement, clearly points to their guilt. Your Honor, the prosecution again respectfully requests that the defendant's motion be denied.
Thank you, counsel. And then, as I just noted, what we will do now is ask the bailiff to call all of the witnesses forward, as it were, and collectively swear them all in. Is the bailiff here? I see a lot of people with hands raised, but I don't see a bailiff.
Will the witnesses please step
Okay,
forward?
there we go.
Please raise your right hand. Do you solemnly swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, and your testimony will comply with the rules of the Ohio mock trial competition?
I do.
Okay. I think we're good. So now we will proceed with the, I need to change my view to gallery again. With defendant's case in chief. So when defense is ready to call her first witness, you may do so.
The defense calls Micah Pesta to the stand.
Very well.
Please state your name and age for the record.
Hello, my name is Micah Pesta, and I'm 17 years old.
Do you know why we are all here today?
Yes, we are here today because I was wrongly accused and convicted of murdering my best friend, Hamea Robbins, who I loved and cared for so much.
Can you tell us a little bit about yourself?
Of course, I grew up in Seattle, Washington, and I'm a good and loving person, but I then moved to Harmony in 3rd grade. Like most younger siblings, I followed my brother around everywhere, even when he didn't invite me. My mother would say I wanted to grow up too fast. And I make stupid mistakes sometimes, but there is so much more to me than my mistakes. Things that I'm not proud of, but regardless of my mistakes, I always own up to them.
When you say mistakes, what exactly are you referring to?
Well, when I was 14, my brother and his friends would smoke marijuana at a park almost every day after school. And like I said, I hung around them often, listened to their conversations, pretending to be in the loop and older than what I was. I smoked once, maybe the first time I hung out with them, but never again after that. One Wednesday afternoon, I was by the school lockers when my brother's friend unexpectedly gave me his marijuana. When the resource officer approached us, I told him that the marijuana was mine. But I just wanted to be a good person. I immediately froze. I didn't know what to say or what to do. I only took the blame because I didn't want my brother's friends to say I was a snitch or a bad person. So I took the blame.
Why did you tell the officer that the marijuana was yours if it was your brother's friends?
I didn't want my brother to get in trouble. I didn't want my brother's friends to get in trouble. And I didn't want my brother's friend to stop talking to my brother, all because his nosy little sister snitched. So I took the fall. Everything had happened so fast, it was a whirlwind. I just wanted to fit in since I didn't have many friends. I guess being a good person comes with its perks.
Did you make any other mistakes involving the law?
Yes, but this one was just truly my fault. I was just trying to fit in with the wrong crowd once again. When I was 16, a new 18 and older club had opened up in Harmony, and everyone wanted to go. So some of my older friends of mine got fake IDs, and they told me about this lady who sold fake IDs. Long story short, I paid her $40, and I got caught with forgery because I got the fake ID. But so did I and a bunch of other underage kids. I just wanted to fit in with the wrong crowd.
Why did you make these mistakes?
Some to fit in, others because I didn't think things through. But I'm still a good person. I know plenty of people who make mistakes, and they are still good people.
What is something you would like everyone to know about you?
I just want everybody to.
I heard the objection grounds.
Your Honor.
I couldn't hear the grounds.
Relevance, Your Honor.
Response.
Your Honor, the threshold for relevance is very low. I would just like to build my witness's character because we are here today to determine her fate of removing the injustice against her.
Yeah, I'll overrule the objection. I can see where the state's coming from, that it may call for a little bit of like an open-ended narrative to go off topic, but since we are at the beginning preliminary, I'll be kind of leaning on this. So as long as it, isn't like 20 minutes, I'll overrule the objection and allow the question if you want to use that tonight.
Thank you, Your Honor. When did you meet Hamaya Robbins?
I met Hamaya when I was in 3rd grade. It was when my family had just moved to Harmony. I didn't know anyone when I first started, so when I met Hamaya, I felt like this was the best time ever. They were so nice to me, showed me around, introduced me to their friends even. I loved Hamaya.
Why do you think the two of you became such good friends?
Like all good friends, they have a lot in common. And me and Hamaya had a lot in common, including our love for music and sports. Hamaya was my best friend through elementary to high school, and even middle school. We planned on going to the same high school and taking the same classes. Talk about a true friendship with an amazing bond. My relationship with Hamaya started growing apart, and we started growing apart. Growing up was been fantastic, the best times of my life even, but Hamaya changed as we grew up, the last years that I knew them, which I always believed was because of their relationship with Scout.
How did your relationship with Scout Farad begin?
Scout had moved to our school our last year of middle school and didn't really know anyone, like I hadn't. After Hamaya started talking to them and soon enough, all of us became friends, all 3 of us. Hamaya always took it as their duty and salvation to include everyone and to make sure everyone felt included and had a friendship. That was one of the things that I loved about Hamaya. And before you knew it, we were all going over Hamaya's house at least twice a week.
How did your relationship with Scout and Hamaya continue to develop?
Well, right away, I knew that Kai, Hamaya's parent, treated Scout differently than me. And I thought maybe it was because Scout was a goody tissues, the best person ever. But Scout had gotten in trouble a couple times just like me. And these weren't mistakes like my instances. I didn't understand Kai's attitude towards me after all. Scout signed up for the same classes as Hamaya and I, so we all had took similar classes. But Hamaya and Scout would hang out separately, alone for class projects or supposedly study. That's right when I became unsure of Scout's intentions.
Why were you unsure of Scout's intentions with your friend Hamaya?
Scout wasn't the best for Hamaya. They were in another relationship at the time, so I really wasn't sure and thought that that was the right thing for them to be trying to get in a relationship with Hamaya when they were in a relationship with someone else. It seemed wrong to me, and not just for Scout to do, but for anyone to do.
Can you hear me now?
Yes.
I had an objection for speculation.
Oh, okay.
Difficulties,
And that cut in and out. I heard that it was speculation, and then we were elaborating on that.
Speculation in regards to how the witness's Scout's relationship with Hamaya.
Okay, response?
I'm sorry, can you repeat that? I didn't hear that.
If I'm paraphrasing correctly, this is for defense counsel, there was an objection as to speculation because this witness may not have direct personal knowledge of the relationship between Scout and Hamaya.
Yeah, that's correct, Your Honor.
It said in their statement that they were in a relationship.
My objection is on the speculation of their relationship with each other, which the witness, which Micah has no knowledge of.
You know what, I'll overrule the objection and allow the question. And here's how it is, that I think that there being in a parent relationship, even if it's just beyond total strangers, is something that a layperson can testify to just as to their observation. And then you'll certainly have an opportunity on cross-examination to challenge that. But I think as far as this person being able to offer their impression that a relationship existed is probably fair and not speculative. So I'll overrule the objection.
Thank you, Your Honor.
Your Honor. Micah Opessa, did you express your concerns to Hamaya?
Yes, I did, and I thought this was the right thing to do, but I was wrong.
What happened after you told Hamea about your concerns?
We ended up distancing from one another. In the past, like normal high school teenage friends, we had fights and arguments, but nothing crazy. I loved Hamea. This time was different though, because Hamea had changed, and I wasn't sure I fit into her life anymore, or if I did at all.
I'm so sorry. What happened after your fight with Hamea?
Well, not long after, Scout began to spread rumors about me at school, even told lies about me to Kai. I was so upset with Hamea because they didn't defend me. They were my best friend. And I had known Hamea for practically my whole entire life. And when she chose Scout over me, it left me upset and lost because I let the drama and arguments get in the way of our friendship.
When was the last time you spoke to Hamea prior to her death?
I hadn't spoken to Hamea a month prior to their death, one of the biggest regrets of my life. I should have fought harder for Hamea. I should have fought harder for our friendship.
Your Honor, at this time, I would like to introduce what has been previously stipulated as Exhibit A. Let the record reflect.
Yes, now, whenever exhibits come in, my usual course is just to ask the other side whether they have any objection to its use. I know that all the exhibits are deemed authentic and admissible. What I'll use as an example, like if you wanted to introduce fingerprint evidence to the victim's mother, there may be, relevance or no foundation. So as to Exhibit A, does the state have any objection to its admission here?
Not to the use of it.
Okay, very well. Go ahead, publish.
Thank you, Your Honor. Ms. Sopesa, do you recognize these documents?
Yes, unfortunately I do. These are the text messages that I sent to Hamea. I was so upset with Hamea, and I sent these messages, but I instantly regretted doing so. I let my emotions get the best of me. And yes, I was hurt. Anyone who would have felt the pain that I felt would have been hurt. It was the heat of the moment. I can't believe I said these bad things to Hamea. But I want everybody, and I hope everyone understands that I was hurt and backstabbed. But this does not mean that I killed Hamea or that I would ever hurt Hamea. This is absolutely the worst thing that I've ever done. And I'm so sorry that I can't take it back.
What happened on August 31st, 2019, the day of Hamea's murder?
Yes, this day that plays over and over in my head. This was the day that Hamea was shot. And I texted him and I wanted to fix our relationship, to talk things out, and to apologize for sending these text messages. I just wanted my best friend back. I'd asked Hamea to meet me at downtown Harmony at our favorite food truck to talk about our relationship, our friendship. And I wanted to apologize, like I said, for the messages. And luckily, Hamea agreed to meet me at 7 o'clock. Our talk lasted from 7 to 7:30. I thought that I was finally getting my best friend back. Hamea and I talked, like I said, for 30 minutes. I remember Hamea dropped their glasses like they always did, and I even picked it up for him. We laughed and we joked about how much Hamea always drops their glasses. I walked away happy and hopeful that our friendship in the future was going to be the best. I knew what was going to happen that night. I would have never left. I would have never asked them to meet me out in the first place. I would have never wanted them to leave. I just thought this was a good starting point to our friendship.
After you left Hamea, what did you do?
I headed to the park to clear my head. There's a pond where I constantly feed the ducks, and I always found that relaxing. I had leftover bread from my sliders that I decided to feed the ducks, and I stayed a while and listened to music and to think about my delightful talk with Hamea. I left the park eventually and went home, hopeful that I could get my best friend back. And I didn't call or text Hamea this night because, well, I thought that I would be overcrowding them. I didn't want them to feel like I was overcrowding them. I just wanted to give them space to think about our friendship. But I would have knew what happened that night. I would have called her a million times.
What happened on September 3rd, 2019?
This was a few days after my conversation with Hamea. The police contacted me and asked me to go to the police station. I was confused, but hey, I thought it was about something about my brother's friends. But I never thought, not in a million years, that this conversation with me later figure out that my best friend would be be dead, and someone that I love so much would be gone. Hamea being gone and me being a suspect is the worst thing that could absolutely ever happen. I offered to call Hamea to clear things up, and that's when the detectives told me that she was gone.
How did you feel when you found out that Hamea was gone?
I was in complete shock. I've never lost anyone so close to me, and I still can't explain these horrible feelings that I go through. Just a few days ago, I was repairing my relationship with my best friend, and now she's gone. I'm literally sick over their death, and I can't grasp it.
Did you think that you would be a suspect?
No, absolutely not. The only crime I have ever committed through everything is being a bad friend for not fighting for Hamea and not texting her that night, and not fighting for her or our friendship. I was so scared because I was like the last person to see Hamea. I have no idea what happened to that night that they died, but I had hope in the detectives, and I had faith that they would believe that I did not kill Hamea and that I cared for them. Sadly, they didn't have faith in me. You know, it's truly a horrendous feeling to struggle with coming to grips that your best friend is dead, and I might go to jail for it.
I'm so sorry. What happened after you were arrested?
A true whirlwind. I had a hearing where the judge decided if I could move forward with the trial, and they wouldn't let me out on bail. And I didn't know what this meant. All I knew is that I couldn't go home. My attorney, Freddie Sticks, had told the prosecutor Oakford that they offered me a 30-year plea deal, and I was absolutely innocent. Why would I take the plea deal when I was absolutely innocent? Second-degree murder? Why would anyone do that? Why would anyone absolutely do that? I told Freddie Sticks that I declined the plea deal. I had enough confidence to go to trial because I had faith in our justice system, that they would see that all I did was love and care for Hamea, and I was just a bad friend. I hoped that would later come out during trial, but everything had pointed otherwise.
What happened after you refused to take the original plea deal?
A month had passed. I was anxious about the trial, and I was advised that an eyewitness had identified me running from the scene with a gun. I was presented with another deal that was 10 years, and I was advised by my lawyer to accept the new plea deal.
You seemed fairly adamant about not pleading guilty to a crime that you did not commit. Why did you take the plea deal and plead guilty if you knew that you were innocent?
I was there the night that Hamea was murdered. My friend Stikes had advised me that someone identified me as Hamea's shooter running from the parking lot with a gun. The eyewitness said that it was me, and there was no way absolutely around it. The reason I pleaded guilty was because of the eyewitness testimony. I would have never took the plea deal if they didn't state that the eyewitness had saw me. This is really strong piece of evidence, which was false, and this had my life on the line. How could I argue with that? How could I argue with something that was said to be me? Why would I put my life on the line like that? There was only one reason I took the plea deal, because of the eyewitness's testimony.
No further questions, Your Honor.
Thank you, counsel. The cross-examination of this witness.
Yes, Your Honor. Now, before I really get into these cross questions, I just want to clarify a few things from your direct questions. It's been over a year since Hamea was murdered, correct? Not a few days, as you said in your direct. Was that just a misspeak on your part?
Yes.
And one more thing, just to clarify, you stated on direct the last time you spoke to Hamea was a month before her death, but then you later on said that you saw her the night of the murder. So was that also just misspeak on your part?
I saw Hamea. I talked to Hamea a few days before the death, but I haven't. Yes.
Okay, thank you. Now, you do have a criminal past.
I was charged
correct?
with forgery as a bunch of other kids where we just wanted to get in a club, and I was a good person. So when my brother's friend unexpectedly gave me his marijuana, I told the resource officer yes.
Okay. In fact, you expected to be questioned about your criminal past when you originally went in for questioning on September 3rd, correct?
When you have a past, people assume that you're always a bad person, or when you run in a law that you did it. But doing a petty forgery and taking the blame for marijuana does not equal murder. The two are not the same.
But In fact, but you expected when you went in on September 3rd for questioning, you were expecting to be questioned about that criminal past. Yes.
I was expected that my brother's friends would be brought up because that's what I got caught with in the past.
However, when you were brought in for questioning, that's when you allegedly first learned that Hamea had been killed.
Yes, the detectives had told me that Hamea had been murdered.
You also mentioned in your statement that you felt scared when the police revealed this to you, right?
I was anxious because I was the last person to see Hamea.
In fact, well, at the time you had a bit of a troubled relationship with Hamea, didn't you?
Me and Hamea were not on the best terms. We were on our track to getting our friendship back.
So far as the one point, you weren't even sure how you fit in Hamea's life anymore, did you?
Yes, I didn't feel like I fit into Hamea's life. They were changing.
So they're vice versa. You weren't sure how Hamea fit into your life anymore, did you?
Hamea was changing, so how could she fit into mine if I didn't fit into hers?
Now, Kai Robbins, Hamea's parent, was aware of you and often didn't want you around Hamea very much, did they?
No, they did not.
Now, being twice convicted of a drug possession and forgery certainly did not help Kai Robbins' impression of you, did it?
I was only indicted on a charge for marijuana for one time and forgery for one time. And that's why, but they were also with Scout, and Scout had made instances that were not mistakes like mine. So I didn't understand how they would not want them around me, but they would want them around Scout.
But to answer the question, that did not help your relationship with Kai, did it, though?
Objection, Your Honor. Objection.
Yes, grounds.
Asked and answered.
May I respond?
May.
The witness never gave me a clear answer on how that affected his or her relationship with Kai Robbins. They just went into how Scout was also there and how I was misspoken about one of the convictions. They never fully answered my question.
May I respond, Your Honor?
You may.
My client cannot speak to Kai's feelings on Scout, only to herself. So her response was accurate in responding on how she thought Hamea's parent Kai was reacting.
May I have one more response, Your Honor?
You may.
I did not ask about. I'm asking about her and Kai Robbins' relationship as a whole, which she does have input on because a relationship is two parts of a whole, and she's half that whole, so she has full knowledge on that relationship.
All right, I'll overrule the objection, and here's more having to do with the basis of the objection was asked and answered, which in and of itself is not really an objection unless it crosses into what's called Rule 403 of unduly cumulative testimony. Sometimes an attorney will re-ask a question if they think it wasn't directly answered, or sometimes even for effect, like you were never there. No, you were never there, kind of is a second point. So the state's counsel, I believe, thought that that the question wasn't answered directly. If it were to go on, I might grant the objection, but I'll overrule it for now and permit the question, and to the witness, answer it to the best you can. And then we'll move on.
Thank you, Your Honor.
All right, I'll just ask it one more time and I'll rephrase it. So, your criminal past overall, your relationship with Kai was a bit more shaky because of it, right?
Kai didn't want me around Hamea because they thought that my past was going to be an influence on Hamea.
Okay, that's a yes. Now, Your Honor, may the record reflect I'm presenting a clear and unmarked copy of Exhibit A.
Does defense counsel have any, since it was just used a moment ago, I guess not. So, yeah, go ahead and publish it.
One moment. We have a bit of old hardware we're using, so I apologize for the technical.
Yeah, that's fine.
It'll load. Here we go.
It's about to load. There we go.
All right.
No.
Now, do you recognize this exhibit?
Unfortunately, I do. These are the text messages that I regret that I sent to Hamea.
Could you read the second message on this page for me, please?
You're both liars and backstabbers, So it's really great you found each other.
Now, can you read the final message as well, please?
I hope you both get the karma you deserve.
Now, these messages, especially the final one, could be easily characterized as threatening on your part, couldn't they?
Objection, Your Honor.
Grounds.
Speculation.
He's asking for her to assume what these were supposed to be perceived as.
May I respond?
You may.
Seeing as she sent the messages, she should be fully aware of how they're supposed to be received.
Yeah, I'll overrule the objection because I think what the question is more of like you sent this with the intent to threaten, I think, rather than whether Ms. Robbins received them in that manner. So I'll overrule it. I think it's a fair question.
Thank you, Your Honor.
Thank you. Now, I'll ask again. These messages, especially the final one, could easily be characterized as threatening on your part, couldn't they?
However, Hamea perceived it, yes.
Could you repeat that, please?
However, Hamea took the messages. They could have seemed threatening.
Okay, thank you. Now, you sent these messages right about a month before Hamea's murder, correct?
Correct.
Now, you did not talk to Hamea for a whole month before her murder, correct? Besides these messages, of course.
Correct. Correct.
Then on August 31st, the night of the murder, you met Hamea near your guys' favorite food truck where her body was later discovered, right?
From 7 to 7:30, I was with Hamea. After I went to a pond, I was not with Hamea with her the rest of that night.
But you were there at the location where her body was found later, yes?
From 7 to 7:30 with Hamea alive.
Okay, thank you. After threatening Hamea and not speaking to them for a month, then suddenly asking to meet them, she was found dead where you met her, right?
After I was gone and not with Hamea. Like I said, I was with her from 7 to 7:30. What happened after is sad, but was not my fault, nor did I have anything to do with it.
Is that a yes then?
Repeat the question, please.
After threatening Hamea, not speaking to them for a month, and then suddenly asking them to meet them, she was found dead at the location where you met her, the time frame being irrelevant. Yes or no, please?
After I was done with meeting Hamea, yes, she was found there dead.
Now, based on the evidence police had found, they later arrested you for Hamea's murder, right?
Yes, because an eyewitness had identified me running from Hamea's scene with the gun.
Now, after your arrest, your attorney, Freddie Sticks, requested a plea deal before you even knew of the evidence against you, right?
Objection, Your Honor.
Grounds.
Speculation. She isn't.
I got half of that. I heard speculation and it dropped after
Lack of personal knowledge.
that. Okay. Response.
In lines 158 to 159 of Opus's testimony, she states how, one moment, please. My attorney, Freddie Sticks, asked the prosecutor about a plea deal to save me the agony of a trial. So the witness was fully aware of this, based off of her own witness statement.
Yeah.
Yes, Your Honor. Her attorney asked about a plea deal, did not ask for a plea deal.
Okay.
Are these ships passing each other? I'll overrule the objection and allow the question, and then if to State's Counsel, if you think that's something to either refresh recollection or impeach with the statement, then go ahead with it. But I'll allow the question.
Okay. We'll just move on then. And because of after him asking about or asking for a plea deal, you later on were completely aware that a plea of guilty meant you were admitting to Hamea, right?
Yes, that I killed Hamea if I would plead guilty.
And the initial plea was discussed before you knew of an eyewitness identification, right?
Correct.
Then on October 15th, you pled guilty to killing Hamea, didn't you?
I pled guilty because I was going to be going to jail for 30 years. The absolutely only reason that I took the plea deal is because the eyewitness identified me running from the scene with a gun that killed Hamea. There was no way I was going to put 30 years of my life on the line rather than I could take 10. It was the best way around it. There was no other way around it than taking the 10 years.
But on direct, you stated multiple times, even with the lack of time being changed, you'd be in prison. You said multiple times how you would have never admitted to the guilt of a crime you didn't commit. You said that multiple times. Now, how is it that changed, even if the time frame of you being in jail changed? Wouldn't you have wanted to go to trial and argue that?
Absolutely not. My life was on the line. Why would I want to risk 30 years of my life when I could just take a plea deal for 10? Even though I didn't do it, there was no way around it. I didn't have faith in our horrible justice system, as they didn't have faith in me.
You said earlier in your direct statement that you had faith in the justice system.
I did, but as they identified an eyewitness that was not true, it was false, I didn't have faith in them anymore.
Okay, moving on. Now, no one forced you to take this plea deal, did they?
No, no one did force me to take the plea deal.
And you also knew that this meant you would be convicted of voluntary manslaughter, didn't you?
Yes, 10 years in jail.
Now, you claim to have doubts against the evidence against you, don't you?
Yes, I do not believe that the evidence was true.
But you also have confidence in your attorney, Freddie Sticks, and trust them, right?
I believe as my attorney that they had the best idea and plan for me.
But apparently you don't feel it necessary for your trusted attorney to argue these doubts in front of a jury in a court of law?
No, because they didn't trust me. They didn't trust me that I didn't do it to Hamea, as they found the eyewitness, but later came out
This
false.
is they you speak of.
They, as in my attorney.
Oh,
So you're saying that your own attorney didn't believe you were innocent?
I don't believe anyone believed that I was innocent.
Oh, okay. No further questions, Your Honor.
Redirect examination of this witness.
In your direct statement, you previously stated that you were, I'm sorry, Your Honor, I'm going to rephrase that.
Okay, however you wish.
Thank you, Your Honor. Mr. Pessa, why did you plead guilty to a crime that you did not commit?
The only reason that I pleaded guilty is because I didn't have faith in our justice system. The eyewitness had said that I was running from the scene and there was no other way around it if someone saw me at the scene.
Did anyone tell you what was best for you when pleading guilty for this crime?
Yes,
And when you pled guilty, you were doing so because of what?
because my life was on the line. It was 30 or 10 years. And with an eyewitness proving that I was there, I decided to take the 10-year plea deal.
Did you trust your counsel, Freddie Sticks?
Can you repeat the question, please?
Did you trust your counsel, Freddie Sticks?
No, I did not.
No further questions, Your Honor.
Okay, recross.
Yes, Your Honor.
Okay,
Yes.
maybe we have a Sixth Amendment issue.
Now, I'd just like to clarify that you do realize that you have to prove your innocence to a jury, not the law enforcement or the court, right? You prove that to a jury. You do realize that, yes?
Yes.
Now, on cross-examination, you said to me that you trusted your attorney, but just in redirect, you said you do not. So what is the true answer? Did you trust your attorney or not?
I'm so sorry, I misspoke. I'm going through a lot right now with my best friend just dying just a year ago and having to bring up all this trauma again.
So which is it? Did you trust your attorney or did you not?
Yes, I'm so sorry for misspeaking. I do trust my attorney.
Okay, thank you. No further questions, Your Honor.
Okay, then with that, the examination is complete. The witness is excused and you may step down. And then I turn to defense counsel and ask if you have a second witness that the defendant intends to call.
Your Honor, at this time, we would like to call Charlie Nguyen to the stand.
Very well.
Will you please state your name for the court?
My name is Charlie Nguyen.
And what is your current job, Investigator Nguyen? I currently own and operate my company, Nguyen Investigations.
And what does Nguyen Investigations do?
Through my company, I work as a licensed private investigator. I've done this for about 10 years now and over 100 cases.
And what have you always worked as a private investigator?
No, I was a patrolman with the Buckeye Police Department, or BPD for short, for about 15 years. I started off as a patrolman and then I became a detective and the BPD's certified evidence technician.
And what training did you have to have in order to become a detective besides being a patrolman?
I attended many seminars and classes on criminal investigations.
Do you have any additional certifications?
Yes, I'm a certified evidence technician with the Buckeye Police Department.
And what did your position as certified evidence technician entail?
I'm in charge of evaluating certain evidence within the BPD's jurisdiction.
And what additional classes did you take to get experience in your field?
I took classes on the analysis and collection of fingerprints and also the analysis and collection of DNA. These classes taught me the importance of following up on tips as they are brought to our attention, interviewing witnesses and suspects, and also keeping an open mind.
Your Honor, at this time, I would like to move pursuant to Mock Trial Rule 702 to qualify investigator Charlie Nguyen as an expert in crime scene analysis and police procedure based on her education, training, and experience in her field.
Okay, I turn to the state and ask if they have any objection to this witness testifying as an expert in this field.
No, Your Honor. With those parameters, we have no objections.
Okay, and then the court independently finds that this witness
you, Your
does
Honor.
have the sufficient education, training, and expertise, and you may examine accordingly.
How did you become a part of this case, Investigator Nguyen?
On October 2nd, 2019, I received a call from Freddie Sticks. He was the lawyer who was representing Micah Opessa in the murder case. He wanted me to investigate a few things for them.
And what was your role as an investigator in this case?
I was in charge of evaluating certain evidence that was found on the scene of the crime. I received a copy of the discovery that the state had turned over.
And what evidence were you asked to review?
The evidence I was asked to review included a partial fingerprint found on the victim's eyeglasses, a footprint that was found at the scene of the crime, and also blue nylon fibers that were found at the crime scene.
And how did you investigate this possible eyewitness?
I called Corey Abrams to discuss with them what they had seen, but they didn't answer my call. I asked them a message asking to call me back. However, they never did, and I didn't want to keep calling them and scare them off. I really wish that they would have called me back because I was very concerned that Micah was identified from a 5-pack photo lineup.
Can you explain the process of a 5-pack photo lineup?
Yes, a 5-pack photo lineup is when a police officer places the photo of the suspect and 4 other individuals who have some common physical characteristics. Some of these common physical characteristics could be same age range, weight, skin color, eye color, hair color, and style. All 5 of the photos need to have the same background, lighting, and distance from the person to the camera.
And what was different about the lineup that Mr. Abrams participated in?
All 5 of the photos were not the same. Witness lineups have also shown that they are mostly ineffective and problematic, and witnesses also feel as if they are obligated to pick a suspect from the lineup.
Your Honor, at this time, I would like to introduce what has been previously stipulated as Exhibit D. Let the record reflect that I'm showing a clean and unmarked copy of Exhibit D.
D, okay. Does the state have any objection to this use?
No, Your Honor.
Okay, proceed.
Investigator Nguyen, what is this document?
This is the partial fingerprint that was found on the victim's eyeglasses.
Are you familiar with the typical procedure for collecting and analyzing fingerprint evidence?
Yes, I am. Fingerprint analysis has been used to help solve crimes for over 100 years now. If you press your fingertip onto an ink pad and then onto a piece of paper, you see friction ridge patterns. Friction ridge patterns are grouped into 3 different groups: loops, whirls, and arcs. Each type has their own unique variation, and no 2 people have the same fingerprint.
And what is different about this fingerprint analysis than those that you've reviewed in your career?
Well, this was only matched with 7 points of similarity. Most of the time, it's matched with 12 points of similarity, and it's shocking to me that it was only matched with 7.
What else is unusual about this fingerprint analysis?
What's also unusual about this fingerprint analysis is, well, as I said before, it only had 7 points of similarity, but the evidence technician did not have their conclusion verified by a second evidence technician.
Thank you, Investigator Nguyen. At this time, I would like to introduce what has previously been stipulated as Exhibit E.
Okay, does the state have any objection to use of? I take it as no. So, yeah, go ahead.
Do you recognize this document, Investigator Nguyen?
Yes, I recognize this document as the footprint evidence that was found at the crime scene.
And what procedures are necessary for correctly collecting footprint evidence?
It must be properly photographed and taken at a 90-degree angle.
Was this shoe print evidence collected at a 90-degree angle?
I'm not sure. It was missing from the report whether if it was or not.
And what impact can incorrect collection have on the validity of evidence?
It can be very harmful. And also, since Micah was wearing a shoe size 9 Converse, that does not mean it is directly connected to him, as any number of people could be wearing that shoe and walked in oil and then walked on that particular spot of the parking lot, because oil can stay on pavement for a very long time.
How so?
Well, anyone who was wearing, like I said, those particular shoes could have walked on the pavement, and then the oil could have been there for a long time. It could have been the day of the murder or even the week before.
And what were your results when you were evaluating the blue nylon fibers?
I found that blue nylon fibers are found anywhere today, and anyone who had physical contact with Hamea while wearing that type of clothing could have left the fibers behind. They could have been from anyone or anywhere. Perhaps Micah and Hamea had just even hugged.
Is it possible with 100% certainty that the time that any of the physical evidence was left can be determined?
No, you never know the time when any physical evidence is left. No expert in the world or crime scene technician would ever be able to tell you certainly how long the fingerprint was on the glasses for, how long the shoe print had been on the pavement, or how long the nylon fibers had been there for, or even how they got there.
Have you formed any conclusions based on the information that you have reviewed?
I believe that there is not enough reliable evidence that it is definitively connected to the defendant. I think all of the evidence needs to be reevaluated immediately to form a final conclusion.
Therefore, in your expert opinion, can the physical evidence be definitively linked to the defendant, Micah Pessa?
Objection, Your Honor, the witness.
I didn't hear the last. I heard the objection and the word witness.
Leading the witness pursuant to Rule 611.
One more time.
Leading the witness.
Leading the witness.
I can rephrase the question. I'm merely asking if she has drawn conclusions and if the evidence can be collected.
Yeah, I was actually going to probably overrule the objection. I didn't. What was the specific question you asked?
I asked if, therefore, in her expert opinion, can the physical evidence be definitively linked to the defendant?
Okay, that's still open-ended and not leading. So you can answer that question if you wish, unless you want to rephrase it, but the question is okay as asked.
Thank you, Your Honor. Would you like me to restate the question? Yes. Therefore, in your expert opinion, can the physical evidence be definitively linked to the defendant, Micah Pessa?
No, it cannot. The fingerprint did not have 12 points of similarity. It is missing from the report whether the shoe print was photographed correctly, and you never know when the blue nylon fibers had been there for.
Thank you. No further questioning, Your Honor.
Okay, cross-examination of this.
Yes, Your Honor.
Okay.
So you currently work as a private investigator for your own firm, correct?
Yes, Nguyen Investigations.
And your previous job in the field of criminal investigation was with the Buckeye Police Department, right?
Yes, that is correct.
And while you have lengthy experience in this field, your only occupations have been with the Buckeye Police Department and now your own firm, the Nguyen Investigations, right?
Yes, that is correct. I'm a certified evidence technician with the Buckeye Police Department and also a licensed private investigator.
I think it's important to note you were a certified evidence technician. Now you work for your own firm, right?
Yes.
Okay. And it's been almost 10 years since you worked as a law enforcement officer, right?
Yes, that is correct. But I did it for 15 years.
And in your role as a certified evidence technician, you only ever handled evidence under the jurisdiction of the Buckeye Police Department.
Objection, Your Honor.
Grounds.
They had no objection to her being an expert in crime scene analysis or police procedure. So this line of questioning, trying to degrade her experience, should not be allowed.
Mayor,
Again, it's kind of the point of cross-examination is that they're trying to do that. So I'll overrule the objection. I mean, they can. That's
Thank you, Your Honor.
sort of what they're trying to do.
so
Right.
Just to clarify, in your role as a certified evidence technician, you only ever handled evidence under the jurisdiction of the Buckeye Police Department, right?
Yes, that was the department that I worked in.
But the criminal investigation into Hamea's murder was conducted by the Harmony Police Department, not the Buckeye Police Department. Isn't that correct?
Well, yes, that's correct. That was where he was murdered, in the Harmony district.
And you never worked for the Harmony Police Department, did you?
No, I did not. I've always
So
worked in
you,
the Buckeye Police Department.
To the witness, the sound has gotten a little garbled. Did the microphone move?
Oh, okay. I can
Okay, there
restate
we
my
go.
answer.
Okay, there.
Could you please repeat the question, though?
so you never worked for the Harmony Police Department, did you?
No, I did not.
And so you have no direct knowledge of the procedures of the Harmony Police Department, do you?
No, but they're typically standard within all departments.
But you don't have any specific knowledge of how the Harmony Police Department operates, do you?
Yes, that is correct.
And you don't have any affirmative evidence that any of the investigation was done, any of the people who conducted the investigation were underqualified or underperformed, do you?
No, it was missing from the report. There was no information provided to me.
And you discussed the verification steps, but you failed to mention that a trained and qualified individual did complete the analysis, comparison, and evaluation stages of fingerprint analysis, didn't they?
Well, yes, they did, but I still don't know if it was done correctly.
But you don't have any evidence it was done improperly, do you?
No, it was missing from the report.
And the analysis and evaluation of the print done by the Harmony Police Department did conclude that that print belonged to Micah Opusay, didn't it?
Well, there was only 7 points of similarity. That does not mean it is definitively connected to Micah.
But despite it only having 7 points, the Harmony Police Department, their criminal laboratory did determine that it belonged to Micah Opusay, didn't they?
Well, yes, they determined that, but it doesn't mean that it necessarily is, because there was only 7 points of similarity rather than 12.
However, they weren't able to fully match the fingerprint because it was only a partial fingerprint, right?
Well, correct, yes.
And only a very small portion of the Buckeye population even has the same fingerprint type as Micah, right?
Actually, it's 812,000.
But that's a small portion of the Buckeye population, isn't it?
Well, it's a pretty big amount if you ask me.
But I'm talking in proportion to the population. Only, I'll just be specific here. Only 7% of Buckeye.
Objection.
Grounds.
Undue delay. My witness has answered multiple times about her opinion on the percentage of the population that has this fingerprint.
May I respond, Your Honor?
You may.
The witness answered cumulatively how many people there are, but I just want to reinforce the actual percentage, which she never stated, which I'll do with this question and move on.
Yeah, I think I'll overrule the objection. I mean, I think he's just trying to put the number 812,000 in context. So I'll overrule and allow.
Thank you, Your Honor.
Okay, so just to clarify, considering the over 11 million people in Buckeye, only around 7% of the population has the same fingerprint type as Micah, right?
Yes, that is correct.
And, sorry. Okay, so only a small portion of the population has the same fingerprint type, and they found 7 points of matching Micah Opusay's known fingerprint. Is that correct?
Yes, that is correct. But typically it's 12 points of similarity. So it's shocking to me that there was only 7.
But there's no national standard, is there?
No, there's no standard.
Okay, so in the opinion of the qualified Harmony Police Department, 7 was enough to determine it belonged to Micah Opusay, right?
Yes, that's what they thought.
Your Honor, may the record reflect that I am now presenting a clean and unmarked copy of what has been stipulated as Exhibit E.
Okay, this is it's what we just saw, right? The shoe print. Yeah. Okay.
So this is a photograph of the shoe print collected from the murder scene, right?
Yes, that's correct.
And you said you couldn't determine if it was the photograph was properly taken, can you?
No, it was missing from the report, but in order for it to be correctly done, it needs to be photographed at a 90-degree angle.
However, you don't have any evidence that it was done improperly, do you?
I have no evidence that it was done properly.
But you don't have any evidence it was done improperly. That wasn't my question. You have no evidence it was done improperly.
No, I don't have either evidence.
Okay. So Micah does indeed wear shoes that are consistent with that shoe print, doesn't he?
Well, yes, he does, but it's a very common shoe.
However, considering a fingerprint was also found, isn't it important to note that a shoe print matching Micah's shoe was also found near the body of Hamea, right?
Yes, it was found by the body of Hamea, yes.
And blue fibers consistent with Micah's clothing were also found, correct?
Yes, but as any number of people could be wearing that type of clothing that had physical contact with Hamea.
Well, but we need to put this in context again. We have, considering the motive and the other physical evidence found, It's important for a criminal investigation to note that fibers matching Micah Opuse's clothing and the description of the suspect were found on Hamea's body, right?
Yes, they were. That is correct. But that does not mean it is definitively connected to him.
Okay, so just to look at the totality of the evidence here, cumulatively, there was a shoe print consistent with Micah's shoes, a fingerprint matching Micah, and fibers consistent with Micah's clothing, all found on near or on Hamea's body, right?
Yes, that is correct. But Hamea and Micah had been together previously that night. So they could have hugged. He could have picked up the glasses. You don't know. It doesn't mean it is definitively connected to him.
But as far as you know, no evidence tying any other individual to the scene of Hamea's murder has been found, has it?
No, but they could have been somewhere else prior to meeting with Hamea or meeting with Micah. Sorry.
We'll move on to the eyewitness identification now. You weren't present when Corey Abrams made his identification, were you?
No, I was not.
And in fact, you've never even talked to Corey Abrams, have you?
No, like I said previously, I contacted him, but he didn't answer my call. So I left a message asking to call me back, but he never did. And I thought it was important to talk to him, and I didn't want to scare them off.
I just want to clarify. You thought it was important to talk to Corey Abrams?
Yes, that is correct.
But you only ever called him once, isn't that right?
Yes, I didn't want to scare them off.
Well, if this is important evidence, I think you probably should have. Do you think you should have tried
Objection, Your Honor.
Grounds.
Undue delay. My witness has said multiple times that she attempted to call Corey Abrams and felt it was important. So there's no necessity for this to be asked repeatedly.
May I respond, Your Honor?
Yeah.
Moving on to from the fact that she only contacted Corey Abrams once to the importance of that fact and whether it affected the criminal investigation as a whole.
May I respond, please?
You may.
My witness has already said that she felt it was important, so there is no reason for this question to be asked repeatedly.
See, I'll overrule the objection just because sometimes you ask the question a second time to confirm it and springboard to another thought, which I think that's what's going on here. So if we start hearing it the fourth time, then you can renew it. But I'll overrule and allow the question.
Thank you, Your Honor. Okay, this will be my last question about contacting Corey Abrams. So, despite you saying it was important to contact Corey Abrams, you only ever tried to contact him once. Only tried to contact the most important piece of evidence in your opinion once, right?
Yes, that is correct, because I was afraid that if I kept calling to ask the question, they would feel that they did something wrong and they wouldn't want to talk to me and they would.
Okay, thank you. And it's true, only 10 days after the murder, Corey Abrams independently identified Micah Opuse as the person fleeing the scene with the murder weapon, right?
Yes, that is correct. However, the witness lineup did not have the same.
I need to know. I just need to know that that's what happened. And just to be clear, Corey Abrams had no knowledge about.
Objection.
Grounds.
My witness was still finishing her answer when she was interrupted by my opposing counsel.
May I respond?
Can she please finish her answer?
Yeah, you may. I'll hear the attorney's response first, and then I'll.
Thank you, Your Honor. I had asked a yes or no question, and the witness had answered yes, and that was all I needed to continue. For the sake of time, we're running low here. I want to continue my line of questioning.
All right. I'll actually, though, just because you asked for just a yes, sometimes it asks. She had a little bit more to say. I mean, if it got narrative, that's one thing. But I'll overrule the objection and allow her to complete the answer.
Okay. Thank you, Your Honor.
To the witness, do you need the question asked again, or
Yes. Could I please have the question asked again?
The question was, it's true that only 10 days after the murder, Corey Abrams independently identified Micah Opuse as the person fleeing the scene with the weapon, right?
Yes, that is correct. However, the witness lineup was not done properly. The backgrounds and the lighting were not all the same.
Yeah, okay, go ahead and ask the next question. That probably got a little off track.
Thank you, Your Honor. So just to be clear, Corey Abrams had no knowledge about the other evidence implicating Micah at the time, did he?
No, he did not.
In fact, he didn't even know the person he was identifying was Micah Opuse, right?
Correct.
And you don't have any evidence that experienced Detective River Foley improperly conducted that photo lineup, do you?
Well, they weren't all the same like they needed to be. They didn't have the same backgrounds, same lighting and distance from the person.
Do you have
camera.
any evidence of that?
What?
Well, you weren't present at the photo lineup, were you?
No, but I saw the photos.
Okay. So one last thing, you're being compensated by the defense for your involvement here today, right?
Could you please repeat that?
You're being compensated monetarily for your involvement in this trial, right?
Yes.
And in fact, you're being paid double your normal fee to be here today, right? And disparage the evidence?
Well, Freddie Sticks did pay me double, but that is standard because it is my job. This is my job. Like, this is how I make my money.
No further questions.
Okay, redirect examination.
Yes, Your Honor.
Okay,
Ms. Nguyen, can the nylon fiber
You're muted.
be concluded-
you're not quite muted, but you may be a bit far away.
Sorry about that.
There you go.
Investigator Nguyen, can the nylon fibers be conclusively linked to Micah Pesa?
No,
Can the shoe print be conclusively linked to Micah Pesa?
no,
Can the fingerprint be conclusively linked to Micah Pesa?
no.
Could this evidence
Hold
have
on,
been left
there
by
was-
someone besides the
excuse me,
killer?
Counsel, there was-
Yes, absolutely.
No further questioning, Your Honor.
Okay.
My objection was those questions were leading. Could I ask the answers to be stricken from the record on that basis?
I'm sorry, could you repeat that? I didn't hear that.
He said that the questions were leading.
They were,
Not leading, they were open-ended. I was
Yeah, I
asking.
actually said, I say the specific questions again, because I think they were open-ended, but I just want to make sure.
Yeah, I simply asked, can the nylon fibers be conclusively linked to Micah? And then I replaced nylon fibers with other pieces of evidence.
Yeah, that's, I'll overrule the objection. It's not, because you could answer that yes or no.
Okay.
Thank you,
It
Your Honor.
doesn't assume the answer, so I'll overrule the objection. But then with that, you are, since those answers now all in and not stricken, are you concluded? And then if so, then you can do a recross.
Yes, sir. Thank you, Your
Okay.
Honor. Despite all the individual evidence, you said you can't conclusively link all the individual evidence, right?
Correct.
However, all the evidence taken as a whole, plus the motive, all pointed towards Micah Opusay, according to the Harmony Police Department, right?
Well, yes.
No further questions.
Okay, then with that, the witness testimony is concluded. You may figuratively step down from the stand, and I will technically ask the defense if they have any other witnesses intended to be presented today. Do we have defense counsel?
Yes, Your Honor.
Okay, do you have any other witnesses you intend to call? I know what the answer is, but I need to ask you. You've had two, so it's good.
Not at this time, Your Honor. We're still
Okay.
sorry.
All right, yeah, I ask it just because in theory, that's what I would do. So now we will turn to the state's case in chief, and whenever the state is ready to begin, you may call your first witness.
Yes, Your Honor. The state would like to call Detective River
Oh.
Foley to the stand. Could you please state your name for the record?
Oh, okay.
And what is your occupation?
I am a detective at the Harmony.
I just want to
Police
stop for a
Department.
second. Do we have a defense counsel on this? Oh, there we go. Okay. I just want to make sure that you were, on it. Okay, very good. Continue.
Okay, thank you. How long have you worked as a law enforcement officer?
I have been a police officer for the past 24 years. I was hired in November of 1996.
And what experience have you gained in your time as an officer?
I attended state investigator training in 2000. I completed over 300 hours of training as an officer. I received the prestigious Master Evidence Technician Award in 2002, and I was eventually promoted to my current role of detective in May of 2003, and I was assigned to the homicide unit at that time.
And how many cases have you worked on as a detective?
As a detective, I worked on over 400 cases, serving as a lead detective in over a dozen.
And what additional training have you received in this field?
I also completed 4 months of advanced criminology training on forensic science with the Federal Bureau of Investigation in 2005. I gained extensive knowledge in evidence handling and various types of evidence such as fingerprints, blood stains, shoe prints, and fibers. I was also trained in crime scene photography and death investigation.
Your Honor, at this time, the state moves to admit this witness as an expert due to their established specialized knowledge, skill, experience, and training. in the fields of forensic evidence and science, specifically including the areas of fingerprint, blood sample, fiber, and DNA evidence.
Does the defense have any objection to admission of this witness as an expert in this field?
While we agree that the expert is an expert in forensic collection, we would like to ask that the scope is limited to these qualifications and that we be able to object in the future if the questioning veers out of these stipulations.
Okay. I mean, I'll do the way I'll put this is the court independently finds that this witness does have the requisite knowledge, experience, and expertise to testify as an expert witness in the forensic and related sciences. To the defense counsel, say that, you know, because we can't really explore that like real deeply. I mean, if they start talking about like, you know, auto maintenance or something like that, then you're clear grounds of beyond it. But if it's something that is arguably within forensic investigation, it's probably more a subject of cross-examination than a lot of individual objections. If it really strays out of the field, then that's fine.
Thank you, Your Honor.
With that, the state may, you know, use Chapter 7 of the evidence rules to conduct the examination.
Okay, thank you, Your Honor. So how did you become involved with the Hamea Robbins murder case?
Well, I have been involved since the beginning. I was one of the officers that responded to the crime scene on the night of August 31st, 2019, around 8:30 p.m. The incident occurred on the First and Green near Popular Harmony Fruit Check location.
And what was the first thing you did at the scene?
Well, I noticed that Corey Abrams, owner-operator of one of the local food trucks, was still in the vicinity of the scene. I thought that they might have some valuable information, so I went to have a conversation with them first.
And what did your conversation with Corey Abrams reveal?
They explained that they were able to get, they explained that they heard gunshots and saw an individual fleeing the scene with a gun. They explained that they were able to get a profile view and a brief view of the suspect's face. While
Objection, Your Honor.
Grounds.
Hearsay, this witness is testifying to what Corey Abrams saw in that moment, not to their own opinion.
Response.
Your Honor, this witness is simply explaining what Corey Abrams informed them of in the course of their criminal investigation, which is important for understanding their knowledge of the evidence, which will be important later. We're not necessarily offering it for the truth of the matter.
All right, I'll admit I don't recall the exact method of how it was being said. So I'll just say to the admonition to, if the witness was testifying as to, you know, yes, they were wearing a blue jacket, yes, they were wearing size 9 Converse, then I would probably sustain the objection. But if you make it clear that like, this is for the witness to say, it was my understanding that, or I was informed that, then that is something that an expert witness in forensic sciences relies upon. So I just don't remember how it was being said. So what I'll do is overrule the objection for now, but just make sure that it's, you know, it's clear that this witness is not kind of offering it as the truth of their own perception.
Thank you, Your Honor.
So again, could you explain what your conversation with Corey Abrams revealed in terms of you learning about the evidence in this case?
Yes. It was my understanding, and Corey Abrams explained to me, that he heard gunshots and saw an individual fleeing the scene with a gun. They explained that they were able to get a profile view and a brief view of the suspect's face. While eyewitness accounts can be unreliable to an extent, they can prove useful in in crime investigation. So I got a general description and noted Corey Abrams' account.
So what did you do after your conversation with Corey Abrams?
I went to talk to one of the crime scene investigators and reviewed the evidence that had already been collected.
And what did you learn about the evidence that had already been collected?
I learned that there had been a partial fingerprint that was pulled from the victim's glasses. I knew from experience that this could prove very useful. I also noted several shoe prints, fibers, and blood stains, all important pieces in solving this puzzle.
And what did you learn about the timeline of the evidence?
It had been quite rainy in Harmony, even well into the day of the crime. While rain often works against crime scene investigation, in this case, it actually helped. We had a high degree of confidence that all the physical evidence was placed either shortly before or during the time of Hamea's murder, and that the physical evidence in all likelihood linked to the murder.
So what was the next step in the forensic process?
The evidence then had to be processed by the lab. Due to a lab backlog and the unfortunate timing of Labor Day, the evidence was not processed until September 3rd.
So what did you learn after the evidence had been processed?
Some of the evidence didn't reveal any new information. However, the fingerprints proved to be vital. The fingerprint that was pulled from Hamea's glasses came back as an arch type, the rarest type of fingerprint.
Your Honor, may the record reflect I'm now presenting clean and unmarked copies of Exhibits D and E.
The record will so reflect. And as these have already been admitted, we'll go ahead, use them, publish them.
Thank you, Your Honor. So are you familiar with this exhibit, Exhibit D?
Yes, I am. This is the analysis of the partial fingerprint pulled from Hamea's glasses being compared to the print on record for Micah Opese.
And could you explain what this analysis shows?
Yes, this analysis shows several points of match, and I have high confidence that the print does indeed belong to Micah Opese. While this is important evidence, I wanted to continue reviewing all the other evidence before making any sudden conclusions.
So how did learning that affect your view of the case?
Well, I had already been familiar with Micah. He had a history of trouble with the law. I had interviewed him after he had been involved in a forgery, and he had been booked for possession of marijuana, which led to his fingerprint being inputted into our system.
Thank you. Could you now please turn your attention to Exhibit E here?
Yes.
I'll just note that the Micah Opese that testified appeared to be female.
Oh, okay, thank you. Yeah, could you please turn your attention to Exhibit E?
Yes.
Do you recognize this exhibit?
Yes, this is a photograph of one of the shoe prints collected from the crime scene. It matched a size 9 high top Converse sneaker.
And what other physical evidence did you review?
We also reviewed fibers from a tailor stitch blue nylon bomber jacket.
And how did this evidence connect to the crime?
Well, it matched the description of the suspect identified by Corey Abrams. Additionally, another food truck owner confirmed that an individual wearing these clothing items had indeed made a purchase at their food truck on the night of the murder. And most importantly, we were able to confirm that Micah Opese was wearing high top Converse sneakers, and a blue bomber jacket on the night of the murder.
So how did you proceed after these revelations?
Well, Micah was firmly a person of interest at the case in this point. I continued to do some more research on her, and I eventually brought her in for questioning.
So what did you learn about Micah at this point?
As I said, I continued to do some more research on Micah at this point. I did some research on her online presence, and I found some concerning posts. These went beyond your usual teenage angst. They were posts referencing betrayal and revenge.
Sorry. So, Your Honor, may the record reflect I am now presenting clean and unmarked copies of Exhibit B.
Will so reflect.
Could you please turn your attention to the Exhibit B here? Do you recognize this exhibit?
Yes, these are the tweets from Micah Opese.
And could you read the final two lines from Micah Opese's tweet on August 9th, the one on the left as we view it here?
Yes. I'm not passive, just aggressive. Maybe it's time you get the message.
So how did this quote specifically and these tweets as a whole affect your investigation?
Well, to me, it appeared that Micah was trying to act tough, and it only elevated my suspicions.
So what did you learn during your questioning of Micah?
I first focused on Micah's whereabouts on the night of the murder. That's when I discovered that she was indeed wearing clothing items that matched the description given by Corey Abrams, and it also matched the evidence.
So what else did you discover?
Well, I later focused on Micah's relationship with Hamea. I learned that the relationship had become tense after some developments between Hamea and Scout Farrat whenever I talked to Kai Robbins, Hamea's parent.
So from your experience, how did these revelations affect your perception of the case?
Well, I mean, It appeared to me that Micah was firmly a person of interest in the case at this point, so I continued to do some more research.
How did the revelations about the Hamea and Scout Barat and Micah's relationship affect your perception of the case?
I have seen many cases involving love triangles and jealousy, so it certainly gave Mike a motive. However, in the interest of justice, I continued to do some more research, and I eventually obtained an arrest warrant.
But what was your next step?
My next step after what?
After talking to Micah, what was your next step before you got the arrest
Oh,
warrant?
sorry. Yes, since we had an eyewitness testimony, I wanted to bring him down to the station for a photo lineup. Due to a convention, our photo lineup was delayed by a few days, but I was eventually able to get Corey Abrams down to the station.
And how did you conduct this photo lineup?
I gathered 5 photos of individuals that matched the description given by Corey Abrams and asked him to identify the person that he saw on the night of the murder.
And what was the result of that photo lineup?
He did indeed confirm. He selected Micah Opesse's photograph and said that that was the person he saw on the night of the murder. I double checked with him to make sure that he was confirming the person that he saw, and he again made the same selection.
So how does identification affect the case?
Eyewitness testimony can always be unreliable to an extent. However, in this case, it only reinforced the fact that we already knew that all the evidence pointed towards Micah as the killer of Hamea Robbins.
So what did you do next?
Well, I obtained an arrest warrant for Micah Opesse. I brought him down to the station, and the standard prosecution procedures were followed. That way we could serve justice.
And did anything significant happen after you made the arrest?
On October 6th, Corey Abrams contacted me and said he was now unsure of his initial identification as Micah Opesse as the person that he saw, that they saw in the night of the murder. I was not sure that this was anything more than some overreaction to some news feeds. However, in the interest of justice, I wanted to give this information to Prosecutor Okafor, that way they would be prepared for the trial. I gave them all my notes, and it was then out of my hands.
So did you have any further experiences with this case?
No, I actually heard that Micah took a plea deal, and I figured that that was the end of it until I was notified that I would be testifying here today.
So in your professional opinion, how important was the eyewitness testimony in this case?
Eyewitness testimony can always be subject to human error. However, as I previously stated, in this specific case, it only reinforced the fact that all the evidence pointed towards Micah Opesse as the killer of Hamea Robbins.
So in your expert opinion, what conclusions can be drawn from the physical evidence alone and what you gathered in your investigation, even excluding the now uncertain testimony of Corey Abrams?
Well, all the physical evidence points towards Micah Opesse as the killer. He was present at the time and place of the murder, and he had motive. Without including the eyewitness testimony, the evidence overwhelmingly shows that Micah Opesse killed Hamea Robbins.
Thank you. No further questions, Your Honor.
Okay, cross-examination.
Yes, Your Honor. How are you doing today, Investigator Foley?
I'm good, thank you for asking.
You're welcome. There was only one identification when you investigated this case, correct?
One eyewitness identification?
Correct.
Yes.
However, you said in your draft that there was a second witness. Was that just you misspeaking?
Yes, I'm sorry, that was just me.
No, you're completely fine. You're a detective for the Harmony Police Department, correct?
Yes, I'm a detective.
And due to your position, you were a responding officer to the site of Hamea Robbins' death, correct?
Yes, I have been involved since the beginning. I was one of the officers that responded to the crime scene.
And when you arrived to the crime scene, you interviewed Mr. Abrams as a possible eyewitness.
That is correct. He was still in the vicinity of the scene, and I thought that they might have some valuable information, so that was the first step I took. I talked to him.
And Mr. Abrams was unable to get a good look at the individual running away due to the darkness.
Yeah, it was my understanding he explained to me that he was able to get a profile view and a brief view of the suspect's face. However, he did see that the suspect was carrying a gun.
But he did not see his face for more than just a few seconds, and it was harder to see due to the dark, correct?
Yes, it was harder to see, but he did get a look at the suspect, yes.
But I'm asking, was the identification lessened because of the darkness?
Yes.
Thank you. And after interviewing Mr. Abrams, you examined the crime scene, correct?
Yes, I went to talk to one of the crime scene investigators and I reviewed the evidence that they had already collected.
And this is where you were told about possible evidence being collected, correct?
Yes, that is correct.
And you were told about shoe print evidence, correct?
Yes,
And it is true that there's no way that you can conclusively say that this shoe print evidence did not occur before the heavy rainfall.
we do have a possible timeline that it could have happened before or shortly before or during the time of the murder due to the heavy rainfall.
But I'm saying that you cannot conclusively say that this footprint was not before the heavy rainfall.
I cannot conclusively say that, but we have a high degree of confidence that it was.
Can you please answer yes or no, investigator?
Yes,
And this collection of evidence led you to the defendant, Micah Pesa, correct?
that along with all the evidence that we had collected, correct.
And this is not the first time that you've interacted with Pesa on the job, is it?
No, I was aware that he had had a history of trouble with the law.
And you were aware of Micah as a suspect before you evaluated the remaining evidence.
Before evaluating what remaining evidence, I'm sorry, can you restate that question?
You hadn't reviewed the totality of the evidence when you were considering Micah as a person of interest, correct?
I had started considering him, but I did not make any sudden conclusions before I reviewed all of the evidence.
But I'm simply saying you hadn't evaluated all the evidence. That's correct.
Yes,
Thank you. Abrams was interviewed close to a week after the crime occurred, correct?
that is correct, yes.
And Abrams' identification resulted in your arrest warrant for Micah, correct?
Yes, it did.
You're an experienced detective. You know that identifications aren't always reliable, correct?
They can be unreliable to an extent, yes.
And Abrams actually contacted you later to revoke his identification. Isn't that correct?
You said that he was unsure of his initial identification, yes.
So he was under the impression that he was revoking his identification, correct?
Yes,
And it's true that after telling Justice Okafor, you took no steps to formally withdraw the identification, correct?
I had then given all the information to the prosecutor for that case, and it was out of my hands. It was no longer something that I needed to take care of. I did my part by giving the information to Justice Okafor.
But it was actually only after coincidentally bumping into Justice Okafor that you even decided to mention Corey Abrams' revocation of his statement, correct?
I was going to talk to Justice Okafor, and that was just the time that I saw her. So I then gave her that information, yes.
But it is true that it was only when you bumped into Justice Okafor that you mentioned this revocation, correct?
Yes, whenever I bumped into her, I gave them that information.
A yes or no answer would suffice.
Yes.
No further questioning, Your Honor.
Okay, any redirect examination?
Yes, Your Honor. So first, they discussed the second witness. Do you know, in the beginning there, do you remember anyone else giving you any other information about him, not necessarily identification, but a description of an individual in the area?
Yes, another food truck owner had confirmed that he saw an individual wearing those clothing items that had made a purchase at their food truck that evening.
Okay, so was that what you were referring to when you mentioned?
Yes.
Okay, thank you.
Yes, that is what I was referring to.
So, and
Objection, Your Honor.
Grounds.
The defense does not see this in the witness's affidavit. Could the opposing counsel please cite the line?
Of course, lines 80 through 83.
Thank you.
So, may I proceed? Should we wait?
You may. Yeah, I guess I'll overrule it. Unless the defense counsel comes back and says that lines 80 to 83 does not, I'll assume it's.
No, we only had an issue with how she answered my previous question.
Oh, okay, all right.
So may I proceed, Your Honor?
Yes, you may.
Okay. And so why did you obtain an arrest warrant originally?
I obtained an arrest warrant because at this point, all the evidence was pointing towards Micah. I did not only obtain an arrest warrant because we had a photo lineup and he identified Micah Opese, but all the evidence was pointing towards Micah.
And so how important was the eyewitness testimony in obtaining the arrest warrant and the investigation as a whole?
As I've stated before, it's always considered secondary evidence and it can be unreliable to an extent. However, it only reinforced the fact that all the evidence was pointing towards Micah.
Thank you. No further questions, Your Honor.
Any recross on that
Yes, Your Honor.
Okay.
We would just like to make it clear, Investigator Foley, there was not a secondary identification, correct?
A secondary identification of what?
Of Micah Pesa.
It was confirmed that another person had seen Micah Opese wearing those clothing items, if that's what you're asking.
No, I'm asking if they identified that person running away as Micah Pesa.
No.
Thank you. And Abram's identification was what resulted in your arrest warrant, isn't that true?
Yes, because as I stated before, I want to look at all the evidence before making any decisions or before coming up with any conclusions. And that was the last piece of evidence that I reviewed.
A simple yes or no answer would suffice. I'm going to ask you again. This was the final piece of evidence in getting the arrest warrant, correct?
Yeah.
No further questioning, Your Honor.
Okay, thank you. With that, the testimony is complete. The witness may step down from the stand, and if the state has a second witness that it intends to call, please do.
Yes, Your Honor, I'd like to call Kai Robbins to the stand.
Very well.
Could you please state your name for the record?
My name is Kai Robbins.
Now, may I ask you how you feel about the defendant, Micah Opese?
Well, he was the monster that was convicted of killing my child, Hamea Robbins.
Yes, you have my deepest condolences, ma'am. How well did you and Hamea get along before her tragic demise?
Well, after my husband passed away a few years ago, it had been rough for us. But despite that tragedy, I know that her and I had a close and loving relationship.
But how involved were you in Hamea's social life?
I was very involved in her social life. She would come to me with everything, from boys to what would have been her incredible future.
Now, how well did you know her friends exactly?
I knew them pretty well from being over at my house so often, especially Micah and Scout, and I would definitely say that Scout was the better of the two.
Well, what was your relationship exactly with the defendant today, Micah Opese?
Well, he had been over at my house a lot, and I'd witnessed him on school field trips a lot too.
So, how would you say you feel about Opese?
I felt that he was a troublemaker and that he was no good for my baby.
Why is that exactly?
I just witnessed too many instances of him being shady. He had forged a fake ID, he was arrested for drug possession, and before a field trip, I watched him forge his parents' signature right in front of me. And when I asked for his parents' phone number, he gave me a fake one.
Objection, Your Honor.
Grounds.
The witness just stated that she witnessed these criminal actions done by Micah Opese, and she was not present during those times. She was just aware of these instances.
May I respond, Your Honor?
You may.
My witness was not testifying that she was there for the criminal actions of like the marijuana possession. She was talking about the forging of the.
Yeah, I was going to say for one of them, she just testified that it was in front of her. She was there. I'll overrule the objection, and then what I'll do is to defense counsel, if on cross-examination you want to straighten that out, that may be the best way to deal with this.
Thank you, Your Honor.
Can you tell us what eventually happened between Micah and Hamea?
Well, Micah and Scout were over at my house one day, and I heard things getting restless in the other room. And I heard Micah yell, "You're going to pay for treating me like this." And then he stormed out.
Could you tell us what might have caused such an outburst?
Well, recently, Scout and Hamea had started dating, and Micah was upset that Scout had chosen Hamea had chosen Scout over him.
Now, I'm sorry to ask this next question of you, but could you please try to give your testimony of what happened the night of Hamea's murder?
I can try. Well, Scout and Hamea were over at my house one night, and Scout had asked me, and Hamea had asked me if he could go over to the food truck because he was getting hungry. And it had been a long time, so I asked Scout if he knew where he had went. And he replied to me crying, and I was very worried. And then Scout told me that he planned to meet Micah at the food truck and showed me the horrible text messages that Micah had sent my daughter.
Speaking of those text messages, Your Honor, I'm presenting Exhibit A to Ms. Robbins. May I?
You may.
Already admitted. Now, could you please read them to us?
Super cool that you're spending so much time with Scout. You two are really perfect for each other. You're both liars and backstabbers, so it's really great you found each other. Just do me a favor and keep your name out of your mouth from now on. I hope you both get the karma you deserve.
Now, as a mother, how exactly do these texts make you feel?
They made me feel horribly as a mother, and I really wish that Haumea would have shown them to me.
Now, could you please tell us the aftermath of that night?
Well, the police had assured me that with everything that I had given them and everything that they had collected, that Micah was the murderer of my child.
Thank you, Your Honor. No further questions.
Okay, cross-examination of this witness.
Yes, Your Honor. First, Ms. Robbins, I would like to say that I am truly, sincerely sorry for your loss.
Thank you.
I can't imagine how hard this must be for you, and I'm gonna make this as easy as possible as it can be for you. You stated your relationship with Haumea was great, even when you fought, correct?
Yes.
And Haumea told you everything, correct?
Yes, everything that he thought he should tell me that would keep my best interest. That would be in my best interest.
Did Haumea tell you where they were going on August 31st, 2019?
Yes.
Did Haumea state with whom they were going?
No.
Did Haumea show you the messages sent to them by Micah?
No, because I'm sure that he was worried that it would worry me, and everything was always in the best interest for me.
I understand. But you were shown these messages by their mutual friend, correct?
Yes, and I can't believe someone had the gall to say such things to my child.
And you made the statement that you had a feeling, I'm sorry, I'm just gonna restart that, Your Honor.
Okay.
You made a statement that you liked Scout the better of the two, is that correct?
Correct.
Therefore, is it safe for me to say that you dislike Micah?
It's not necessarily that I disliked Micah, it's that I'd witnessed too many instances of him being shady to trust him.
Were those instances directly between Haumea and Micah?
No, they were just between him doing things that would get him arrested and things that were illegal.
So Micah made some bad decisions, in your opinion, is that correct?
Absolutely.
Yes. Miss Robbins, when you talked to Haumea about dating Scout, were you happy that she had chose Scout instead of Micah?
Yes, I always thought that Scout was a great kid.
And you stated that you thought that the thought of Micah having a crush on Haumea concerned you, correct?
Yes, because of all of the illegal activity that he had participated in, I was afraid that it would rub off on my child.
And wasn't it a detective who convinced you that Micah was guilty?
Well, I had a lot of evidence that I was with that also went with the police's evidence.
You had the evidence.
Well, the police had the evidence, but I had a few things that I gave to the police as well.
So it was the detective who actually convinced you and asserted that your predictions were true, that Micah was the murderer of Haumea.
The police had told me that, yes, that with all of the evidence collected together, that he was the murderer of my child, yes.
Okay, and I'm sincerely sorry for your loss. Miss Robbins, do you want justice for Haumea?
Yes.
Well, we would too, Miss Robbins, and that's what we're trying to achieve today. No further questions, Your Honor.
Okay, any redirections?
Yes, Your Honor.
Okay.
Could you please reiterate for us why exactly you thought Micah was a bad influence on your daughter?
He had just had too many instances of him being shady. He had completed a lot of illegal activity that I didn't want to rub off on my child.
Now, are you currently aware of the guilty plea that Micah pled to?
Yes.
How does this make you feel about his guilt from a mother's perspective?
From a mother's perspective, it just makes me feel like he was guilty with all of the evidence collected.
No further questions, Your Honor.
Any recross as to that line of question?
No further questions, Your Honor.
Okay, then with that, the testimony is complete and the witness is excused. And as a matter of formality, I will ask the state if it has any other witnesses that it intends to call.
No, Your Honor, the state does not.
Okay, then with that, at this portion of the trial, what will happen as soon as I finish speaking is each of the sides will have 2 minutes. That's a light that just fell out of my ceiling. Each of the witnesses will have 2 minutes to, or the attorneys will have 2 minutes to collect their thoughts, look at their notes or whatever, and before closing arguments. And then, so what I will do is, for the moment, turn off my camera and microphone, and we'll ask the bailiff to begin the 2-minute count as soon as I say here in a moment. And then after 2 minutes to either come on screen or put something on chat that the 2 minutes has concluded. So with that, that period shall begin.
I will say.
The 2 minutes has expired.
Yes, I see that. And so with that, we will go to the final phase of the trial, which is the closing arguments. And because the defense has the burden in the case, they get to give the first closing argument, and they're also allowed 2 minutes of a response argument to the state's closing. So with that, whenever the defense is ready to begin her
Yes.
closing argument, you may do so.
Thank you, Your Honor. May it please the court. It is a fundamental right guaranteed through the 14th Amendment that fair process is followed and due process is applied. However, this right was not upheld when the prosecution failed to turn over evidence that they knew would ruin their case. As stated in Brady v. Maryland, the prosecution must turn over all evidence that might exonerate the defendant to the defense. Micah Pest's 14th Amendment right was violated by the prosecution's actions, or rather lack thereof. Today, the defense has proved 3 prongs that show Micah Pest's rights have been violated, and therefore she is entitled to withdraw her guilty plea. Number 1, the state fails to disclose exculpatory evidence within their control. 2, Corey Abrams' suppressed statements had a reasonable probability of leading to a not guilty verdict. And 3, Micah Apessa's guilty plea was not knowing nor voluntary under the circumstances. Through the cross-examination of Foley today, we have shown that the prosecution failed to disclose the recanted statements despite being told of the change by Detective Foley. This violates Micah Apessa's 14th Amendment right, despite the prosecutor's intention of the non-disclosure, as established in Kyle v. Whitley, which states that it is the affirmative duty of the prosecution to learn of any evidence in the hands of any other party, including the police, and that the prosecution must turn over all evidence that may shed a different light on the case. Through the testimony of Charlie Nguyen and her evaluation of the totality of the prosecution's evidence, the defense has proven that Corey Abrams' statements had a reasonable probability of leading to a not guilty verdict. Without the witness statement of Corey Abrams, there's little to link Micah Apessa to the crime or to being the person who murdered Hamea Robbins. As Nguyen's expert testimony revealed, the physical evidence could not be definitively connected to the defendant for a multitude of reasons. Number one, the fingerprint evidence did not have 12 points of similarity and was not reviewed by a second examiner. Number two, the oil found at the scene of the crime could have been on the pavement previous to the crime and therefore cannot be definitive. And three, and finally, those nylon fibers found in Hamea's glasses could have been linked to anyone. The defendant Micah Apessa's own testimony directly proves that her guilty plea was not knowing nor voluntary under the circumstances. At the time of her plea deal, Micah Apessa was unaware of Abrams' withdrawn statements, and therefore she was unable to make the proper decision. Consequently, Micah Apessa is a victim of manifest injustice, which has been defined as an extraordinary and fundamental flaw in the plea proceedings. Therefore, as established in Boykin v. Alabama, Apessa's plea was not voluntary nor intelligent, and as a result, she is entitled to revoking her guilty plea. Today, the prosecution attempted to form a young grieving friend as a hardened criminal. Through her testimony, Micah showed her love and dedication for Hamea and explained her crimes, both of which were nonviolent mistakes that were made by a teenager. There are two victims in this matter. Hamea Robbins, a young person with their life ahead of them whose family deserves justice, a victim of violence, and Micah Apessa, a young woman who is the victim of a flaw in the system, a victim of the prosecution's actions who was scared to face the system alone. The defense wants justice not only for Micah Apessa, but for Hamea Robbins, so the defendant will no longer suffer for a crime she did not commit while attempting to mourn the loss of her dear friends, and so that the real culprit of Hamea Robbins' murder will be brought to justice. Therefore, we request that the Honorable Court grant the defendant's motion to withdraw her guilty plea under Rule 32.1. Thank you, Your Honor.
Thank you, counsel. And now we turn to the state for its closing argument.
Thank you, Your Honor. Your Honors, may it please the court and opposing counsel. The state respectfully requests the defendant's motion for withdrawal of their guilty plea be denied. The defendant, Micah Apessa, knowingly and voluntarily pled guilty to voluntary manslaughter in the killing of Hamea Robbins. In this case, justice was served and it must be upheld. The defendant's constitutional right to due process under the 5th and 14th Amendments was not violated. The defendant is making their motion to withdraw under Rule 32.1, which requires the defendant to prove a manifest injustice has occurred, which will permit such withdrawal. However, the defendant has not clearly and convincingly shown that a manifest injustice has occurred. In fact, we have proven that any allegations of a manifest injustice are unfounded. The defendant alleges that Prosecutor Justice Okafor's failure to disclose the reservations of Corey Abrams rises to a due process violation under Brady v. Maryland. However, even assuming that the evidence withheld falls under Brady, which the state entirely disputes, in Campbell v. Marshall, the Sixth Circuit Court of Appeals determined the question presented in the instant case is not so much whether the conduct complained of violated Brady, but instead whether the petitioner's guilty plea was intelligently and voluntarily made. Campbell was a case specifically about evidence not turned over in plea negotiations, unlike Brady. In this case, there is no evidence that the defendant's guilty plea was not knowing nor voluntary. Further, the Supreme Court of the United States held in Ruiz v. United States that the Constitution does not require the government to disclose material impeachment evidence prior to entering a plea agreement with the criminal defendant. The protections of the Constitution, Brady, and Giglio are protections meant to ensure fair trials, and the guilty plea is a waiver of the right to such a fair trial because according to Campbell, plea agreements are made without perfect knowledge of the outcome or factors of a trial. Ruiz and Campbell make this distinction clear. The prosecution had no duty to turn over exculpatory or impeachment evidence prior to the plea bargaining phase. Justice was served, and it must be upheld. Furthermore, Corey Abrams' reservations do not even rise to the standard of material evidence according to legal precedent. In Kyles v. Whitley, which the opposing counsel quoted, the Supreme Court established that the favorable evidence could reasonably be taken to put the whole case in such a different light as to undermine confidence in the verdict in order to be material under Brady. The testimony presented here today, namely by River Foley, today makes it clear that the mere reservations of Corey Abrams do not rise to that materiality standard. First, we called Detective River Foley to show that the physical evidence found at the crime scene clearly implicated the defendant as the killer of Hamea Robbins. She explained using her expert knowledge that the analysis of the evidence clearly showed that Micah Opusay was the killer, even without the testimony of Corey Abrams. And then the emotional testimony of Kai Robbins, the mother of the victim, showed that the defendant had motive for killing Hamea and threatened Hamea previously, and then didn't talk to them for a month before meeting them at the place of their murder. With or without the eyewitness account, it is clear that the defendant killed Hamea Robbins, which Detective Foley showed to us today, and Kai Robbins showed the motive that the defendant had. Today, the defense handsomely compensated and called Charlie Nguyen in an attempt to discredit the evidence that clearly implicates the defendant. Despite this, we showed that Nguyen had no direct knowledge of the investigation and never even worked for the police department that conducted this investigation. His expertise is, while broad, is not applicable in this circumstance and cannot exonerate the defendant and does not invalidate the great investigative work of Detective River Foley. The defense also called Micah Opusay today, who could not even figure out whether or not they trusted their attorney. At one point they stated they didn't, and then one point stated they did, and then failed to have their attorney argue their doubts about the evidence in a court of law. The defendant has already knowingly and voluntarily pled guilty to the murder of Hamea Robbins, which they admitted to today in this court. They said they knew that a guilty plea meant they were going to spend meant to killing Hamea Robbins, and that they did it without anyone pressuring them to do so with their competent counsel fighting sticks. They waived their right to a fair trial and waived any right to the perfect knowledge of the results of the trial under Campbell v. Marshall. The defendant cannot prove the necessary manifest injustice in this case because justice was served and it must be upheld. The state therefore respectfully requests that defendant's motion for withdrawal of their guilty plea be denied. Thank you, Your Honors.
Thank you, counsel. And then with that, the defense is permitted, I believe, 2 minutes for a response closing if you wish to do so.
May I proceed?
You may.
Justice was not served today. Justice was not upheld today for either Hamea Robbins or for Micah Opusay. This is why we are requesting that the Honorable Court grant the motion to withdraw Micah Opusay's guilty plea. The burden to prove manifest injustice is clear and convincing evidence, which we have met today. The prosecution's evidence has been proven doubtful through the expert testimony of Charlie Nguyen. The expert testimony of Charlie Nguyen, using her education and background, shows that without the statement of Corey Abrams, there would have been a different light shed on this case. Charlie Nguyen's testimony revealed that the evidence cannot be definitively connected to the defendant for a multitude of reasons. Number one, being that the fingerprint evidence was not evaluated by a second evaluator and did not have 12 points of similarity. The footprint was not conclusively linked to the defendant either. And lastly, the nylon fibers could have been left by anyone, as explained by Charlie Nguyen. Micah Opusay's own testimony shows that she was not aware of Abrams' statements when making her guilty plea, and therefore she's a victim of manifest injustice and is entitled to withdrawing her guilty plea. Now, today, we come before you to ask for justice. Even if this evidence is Micah's, that does not mean she's a killer, and that alone raises reasonable doubt. We are asking for justice for Hamea Robbins and for Micah Pessa. We are not asking for exoneration. We are asking for justice. Thank you, Your Honor.
Thank you, counsel. And with that, the case is heard and submitted. May change my view here to gallery. And what we do next is I first turn to the bailiff and timekeeper and ask if between the two of you, you perceived any significant time discrepancy between the times kept by you.
No.
Okay, there never is. So with that, what I will do is ask the scoring judges to complete their score sheets, and then the rules of this jurisdiction also require that at the conclusion of trial that I read the following statement. Does either team have serious reason to believe that a material violation of any rule has occurred during this trial? I will remain on the bench for 2 minutes, during which time any protest or objection may be brought to my attention by a team attorney. The team attorneys may communicate with any student team members involved in this trial. So that includes the 2 attorneys, the 2 witnesses, and your bailiff or timekeeper, but you may not confer or communicate in any way with others, such as your legal advisors, teachers, or anyone outside of the performing team members in this trial. So I will begin that 2-minute period in a moment, but we'll also conclude by saying that if either team believes before the end of that 2 minutes that they don't have any intention to raise an objection, you can certainly bring that to my attention before the conclusion of the 2 minutes. So with that, to the timekeeper, begin the 2-minute clock.
Your Honor,
The defense has no material violations, Your Honor.
Okay,
the prosecution has no evidence of material violation.
I kind of figured that was the case. All right, let me finish my score sheet and review. I believe I am completed as well. Let me just get a confirmation that it's gone through. Oh, usually it takes 1 second for me to get the thank you for submitting your score sheet, but for some reason it's thinking about it. Well, you know what? I'll just assume that this is going to go through and there's just something with Wi-Fi traffic now. So what we'll move to the final phase of this case, which is where the scoring judges and I are allowed to provide commentary to the teams. And because you have heard me speak all of this time, I'll ask the scoring judges to turn on your cameras and provide any commentary that you may have, and then I will conclude with mine at the end.
Your Honor, may I say something before you begin?
Sure.
One of our members is no longer present because she had to run. So if you see that Micah doesn't show up, that's why she's just not present right now.
Oh yeah, yeah.
Thank you.
Okay, I'm just curious why. Let me do, for some reason my my score sheet is hanging, but I guess that's my problem. The scoring judges can give comments as they wish now.
Sarah, do you want to go first this time?
Sure, I can go ahead and go. So you guys both did a great job. I really enjoyed hearing everything, and I saw some different witnesses that I hadn't seen. I'm just going to give you really general, quick comments. So I just noticed on both the openings, they were a bit argumentative. So I would just watch that on both sides. I think overall, everybody could slow down. I know the timing, you were hitting the time, but you've got to prepare for that. You have to shorten your examination so you can fit within the time. When you're going super fast, it's hard for us to hear what's going on, and it also just takes away from your character. I think everybody could work on objections. You don't have to cite the rule number, but at least citing like the one word, what the name of the objection is, would be helpful as to opposed to just going straight into an argument. And the genders, since you guys did bring that up, it is just important to keep up with that on both sides as well. So, the other side, if you agree to that in the beginning, and I know it's not real, so it's, it's hard, but it just makes it a lot nicer. I mean, we were referring to Micah as a he in a romantic relationship when Micah said that it was a friendship and Micah was a female. So just watch that stuff. And then the other thing is, I would just try to remember what you're looking like on camera and how you're appearing. You guys have two different setups, and however you feel, but you have to remember to be professional, and that we're kind of watching everything you do like we were there in person, and especially the defense. I mean, just, and listen to your coach. You don't have to listen to me, but my observation was that it was very distracting. Every single time someone else came in and out of the screen, I was always like wondering what was going on. And you guys actually appeared to be speaking to other members of the team throughout the course of the trial. So, we can see all of that. We can see your faces and your eye movements. So I would just suggest trying to find something a little less distracting in the future. But other than that, you guys did a great job, and this is kind of a complicated case and our legal arguments. So good luck on your future trials, and you did a great job.
I would very much agree that I think everyone did an excellent job. I very much got the sense that this is a slightly more complicated procedural motion, and it can sometimes get lost what you're trying to get to. And it can get lost too, understanding and applying those rules and precedents. You don't want to just sprinkle them in sort of willy-nilly just to kind of check that box. It seemed like they were used effectively in your arguments, and then meshing your witnesses together with the law to make your case come together. That's what we're here to do. I thought that was very effectively done by both sides. And I got the sense from each witness what avenue you were trying to go down. And the witnesses all around, I felt very much that they were in their character. Sometimes this might lend itself, particularly over Zoom, to witnesses and attorneys interacting in a more stilted way, almost like you're reading a script from one another. I didn't really sense that. I think when there were objections, and I noticed I mean, I still do this. If you start a question and you don't like where it's going, you just stop the question and you say, I'm going to rephrase that. I thought that's a good skill to have, to know when you're like, I don't like where this is going, and to kind of correct yourself before you ask it an objectionable question, because that can get you off your rhythm. So all around, I thought everyone did a great job. This is a year that I think a lot of people might have said, maybe I'm not going to do it, or there's lots of excuses to why things don't work. But I think that both teams, I'd echo some of the distracting things that Sarah mentioned, but other than that, I think this was done well, and I enjoyed watching both sides present their cases.
And I'll just conclude with echoing the sentiments that I thought it was a well-tried case. I enjoyed the morning doing this and thought that across the board that the witnesses and attorneys did a fine job, and the timekeeper, in presenting the case. And so I just want to say thank you not only to the on-screen participants, but also to the off-screen participants, such as the coaches and legal advisors and family members and observers. And I hope you enjoyed the trial. I hope you had a good time. And I wish each of you continued good fortune as the tournament continues. Thank you.
Thank you. Thank you. We
Right.
appreciate you taking the time out and giving us commentary. We appreciate it. Thank you.
No problem.
Thank you.
Thank you very much.
So,